So thanks to the first roundtable, we now know the legal status, the different types of crypto assets, and the disputes that typically arise in litigation as well. Now we're going to really dig into deeper with arbitration. I already introduced our wonderful panelists. Just as a reminder, Nino Sievi from Switzerland on my immediate right, Qian Bao from Singapore in the middle, and Mariel Dimsey from Hong Kong next to Matthias. And you will find the full bios, of course, on the Paris Arbitration Week website. We should also say that we do have an opportunity for Q&A at the end, so please keep your questions coming at the end of this roundtable. But now, taking from what we've heard on the first panel, Nino, let me start with you. We've heard a couple of what types of cases do arise, what type of disputes do arise. Which are the ones that end up in arbitration, according to your experience?
All right, I'll try to speak closely enough to the microphone so everybody can hear me well. First of all, thank you for having me, and thank you to all of you for showing up. It's great to see that so many people are interested in crypto arbitration. And the big question is, I mean, does it even exist, crypto arbitration? Are we just making stuff up so we have panels to fill? No, these cases actually exist. And I would say we have three different categories of cases that we can look up. First, you have your frauds, your hackings. Chloe mentioned that before. And then you have just your off-chain normal contract disputes that do relate to a crypto transaction. And third, you have pure on-chain disputes that relate to a blockchain issue and that they are resolved on blockchain on a smart contract via a decentralized justice protocol such as Kleros. They're still quite exotic. I wouldn't say that they're at the moment particularly attractive to your typical arbitration practitioner because they simply do not have those juicy cases that we all would like to have. But coming back to the fraud cases, I mean, you have your fraudster. Can you go against your fraudster in arbitration? Difficult. If you manage to locate him, to identify him, these fraudsters, at least in my experience, Chloe, correct me if I'm wrong, they're not overly cooperative. They will not sign an arbitration agreement. If anybody out there manages to find the proper fraudster and sign an arbitration agreement with him, please give me a call. I'm happy to send you a bottle of really good wine. But what you can do with fraud claims is if you have an exchange that is involved or a wallet provider and you can prove that they messed up, that they had a gap in their security system that enabled the fraud, then you might have a claim against them, and they, in their terms of use, they often have arbitration clauses. So this is your fraud arbitration claim that you can try to launch. Now with the off-chain contractual disputes, they're not rocket science. I mean, they're contracts in the end, and what you see is you see claims against crypto exchanges because the users, they have terms of use that they can use to launch their claim. Then you have your financing agreement, for example, lending agreement with a crypto hedge fund. Very often they end up in arbitration. Right now there's a public case going on at the Swiss Arbitration Center with Stakehound. Then you have a lot of cooperation and joint venture agreements between the different startups in the crypto ecosystem. And you have a lot of investments in startups that are structured via tokens. So you have token purchase agreements or simple agreements for future tokens. And they very often, they have an arbitration clause. And these arbitration clauses, they're not necessarily well drafted, but they're enough to at least get you to ad hoc arbitration. You will see ICC arbitration, Hong Kong rules, Swiss rules. I still have yet to say which one is the leading institution when it comes to crypto arbitration.
Well, I guess we're going to ask Mario that question later, but Qian, maybe if I can just continue with you. Why and when do you think arbitration would be more suitable for these types of disputes than litigation, for instance?
Yes, exactly. Thank you very much, Maxi. Arbitration is almost made for purpose for these types of crypto disputes, for the very basic principles and attributes of arbitration that we all know about: the neutrality, the cross-border nature, and the enforceability of arbitration awards, the confidentiality, all of these basic first principles, first attributes of arbitration make it ideal as a forum for resolving disputes that are inherently cross-border, quite amorphous, dealing with requiring confidentiality, requiring multi-jurisdictions, requiring specialist adjudicators. All of these attributes are, in fact, quite important. The only area where I would see litigation being perhaps more suitable would be in injunctive relief circumstances. And that is where I think you see a lot of the disputes that are coming out in the court systems in the first instance. And of course, litigation happens when, and there are many crypto disputes in litigation because there isn't an arbitration agreement. But if there was foresight to engage in arbitration agreements at the outset, I think many more of these types of cases would be in arbitration.
Mariel, I'm sure you can comment on everything that has been said so far, but I also want to hear your particular perspective from an institutional role as of 2 weeks ago, because you've probably seen more crypto cases than anyone else. So what are the typical features that you see, and what, in your view as well, is the role of an institution in administering them?
Thank you, and thank you also for the kind invitation to speak. Just as the sort of very recently institutional disclosure, obviously I'm not talking about ongoing cases that the HKIAC or anywhere else had. I'm talking more about general points that have arisen as a result of seeing these kinds of disputes go to institutional arbitration. Just to pick up on what Nino said at the outset, I think this is the key point, right? Because you're not going to get a lot of these disputes, particularly the fraud cases that were discussed by Chloe and by Anne-Claire. They're not going to go to arbitration because there's no agreement, and we'll get to the suitability of arbitration for these types of disputes more generally in a moment. So what you're looking at in an institution when these kind of disputes come to arbitration, and they are on the increase, we did have a good increase over the last 3 years at HKIAC in fintech disputes, including a large majority of crypto disputes within there. But what you're looking at in those circumstances is the agreement that led to that being in the institution in the first place. So it's largely platform-related disputes where you've got individuals. We can turn later to whether or not they're consumers, but individuals coming up against a platform provider. Now, as was disclosed in 2021, there was an outage, for example, on the Binance platform. Binance had a history of changing their dispute resolution clauses over the years, but at the time when this happened, Hong Kong and HKIAC was included in their T&Cs. At the same time, as is also in the public record, Binance had also included a prohibition on class arbitrations in that same clause. So as an institution, you can imagine the kind of issues that you're dealing with. Most institutions have rules to deal with concurrent proceedings. So if you're not doing a class action style of proceeding, you may be looking at a concurrent proceedings kind of model, which then for the institution begs questions like, what kind of arbitrator or arbitrators do you appoint? Obviously, if you've got several concurrent proceedings, the more arbitrators you appoint, the more the risk of conflicting decisions at the end, or there being some sort of disconnect in the speed and the way these proceedings are conducted. Also, in that context, you need to look at the pool of arbitrators who are able to do this kind of work. If you're going for the model of trying to get as fewer arbitrators as possible into that kind of concurrent model, you obviously want someone who's got very good case management skills. We'll turn in a later section of the speech or the panel presentation to the types of characteristics or the types of arbitrators we appoint. But I think for institutions, there's a whole host of challenges that come up in these kinds of disputes that you don't necessarily have in other sectors. One thing that I observed through watching these disputes in my role was that, and we'll get to particular attributes that institutional rules should have for these kind of disputes, is that if you're dealing with parties that have sophisticated counsel on both sides. The same kind of procedural tactics are going to be there regardless. So you can have these aspirational ideas that we have this, not an on-chain form of dispute resolution, but it's quick, it's efficient, it's all electronic. We'll do this, we'll do that. But short of mandatory rules, and most institutions don't like mandatory rules very much, if for no other reason that they usually conflict with the law at the seat or the law where the institution is located. If you've got facilitative rules and it's the institutional phase of the arbitration, we have a very limited role, or the institution has a very limited role. We have thresholds that we need to get past to ensure that a tribunal is constituted, to ensure that the case file gets transferred to someone who's actually making the decision. So if you've got parties who know how to play the game, it can make very little difference in some cases whether it's a crypto dispute or any other dispute, because if one party's trying to delay, for example, and the other party's trying to push it forward, you'll have the same challenges as you'll have in any other setting. So I'll stop there on the institutional role.
Thank you. I have actually one follow-up question before I hand over back to Matthias, and that is following up on what you've just said. What are the characteristics that you, from an institutional perspective, or maybe also from a party's perspective, would look for when appointing an arbitrator in these types of disputes?
Should I do institution first and then you do party? Sure. Okay. From an institutional perspective, and moving away from the sort of concurrent multiple proceedings, we had a lot of opportunity to look at this model or this profile during my time at the HKIAC, and it's a lot of things coming together. Just to sort of bring out a couple of points, you obviously want the subject matter knowledge, the sector knowledge, but that's quite difficult because it's a burgeoning area. A lot of people are just getting up in that area themselves. What we tried to do, or what we looked at least, were people with a TMT, a fintech, even an IP background. Given that there was quite a few different kinds of crypto disputes that were coming to us, we were looking at sort of the core behind it. Is it actually an on-chain crypto kind of thing, or is it at the end of the day, is it a contractual dispute where we need someone who can interpret a contract, as most arbitrators can, but with a bit of fintech background to be to add to it. On top of this, a lot of these disputes are very low value. So particularly, I mean, in HKIAC, we had a choice between the ad valorem and the hourly rate system, but assuming in a lot of rules the ad valorem is the default, you're going to have to find someone who fulfills all these wonderful sector attributes, but is also willing to do the job well for quite a low fee. A couple of other things, you do need someone with good case management. This goes to the point made before that a lot of the issues that come up in these kinds of cases are being put forward by people who are very adept at moving in a sort of delocalized, deregulated world, so you might need some experience there. The last point I'd say is that nationality issues may also come up, particularly because you may be getting people from all four corners of the world. You've got one or several defendants on the other side. And this goes back to the point about the parallel. If you've got several of these cases that you want to run in an efficient, coherent manner, you probably are going to have to exclude a lot of nationalities from the outset. So they were our challenges as an institution.
Sure. I mean, the one request I get from my clients is when they go to arbitration is that we're going to have an arbitrator that really understands crypto. And if they get a sole arbitrator appointed by an institution, they usually are disappointed. I'm not saying that the institution appoint the wrong people, but their idea of having a proper crypto lawyer doing an arbitration would probably not work in the end, because you need to have someone who has a very good understanding of arbitration. But what I tend to say is, I do not want to have an arbitrator who understands the technical issue. He doesn't need to understand how the blockchain really works or any of those things. What he needs to have is an understanding of the industry, of the people who are working in that crypto ecosystem, because they are a bit different. I mean, if you've ever seen a contract from a crypto project, I mean, the drafting, it's horrible. I mean, it's obvious copy-pasting going on, contradictory clauses, and you want to have a person coming to the case with an understanding, with a sensibility to that. Because if you just send your average Joe banking lawyer to that case, and he sees the contract, I mean, he's going to think, this is a fraud, it's an outright fraud. Nobody would write a contract like that. Trust me, they do write contracts like that.
Just to move on to another subtopic, which is the typical issues coming up in crypto arbitration, and it has been briefly mentioned by Marielle, the issue of class or mass arbitration. This is one of the questions that arise from the confrontation between arbitration and cryptos. And can you share your views on this with us, Nino?
Sure. I mean, Marielle has already given a very good overview of that issue. I mean, it comes down to there's usually one event affecting a multitude of people. So typical examples are crypto exchanges. When you have an outage of the exchange, you have a multitude of users that get affected by that. Same if you have an investment in a startup company, and for example, they lied. One of the misrepresentations wasn't right. You have a multitude of investors that will want to sue that company. Now, the problem here with arbitration, we do not really do collective redress. This hasn't really been properly established. You do have the AAA rules. They have a class action claim. I give you that. But other than that, we're stuck with joinder, consolidation. We have to get creative. And this is not ideal because, as Marielle said, many of those claims, of those mass claims, they are for a very low amount. And it's very difficult to find funding for those cases. If already at the outset it's unclear, will we get consolidation or not? How are we going to run the case? So I mean, I was very amazed because there's this one case at the HKIC with Binance where they managed to find funding. I so far was not able to find funding for any of those cases because it's just too unsure how this will proceed on the institutional level. And
related to mass arbitration, there is this issue of consumers. It has been mentioned several times, even during the first panel. And Chan, maybe you have something to say about that, about consumer and arbitration in cryptos.
Yes, exactly. I think this issue as to consumer touches on a broader public policy issue, which we'll talk about in later on as well, but in particular in relation to consumer, the point is as to arbitrability of the dispute in the first instance within arbitration. And now, so many of the national legislation will have consumer protection laws which protect consumers, and if they are not dealt with within the arbitration by the arbitrator and applied within that, or at least addressed within, they could be subject to set aside. And this has been seen in the UK courts in Nifty Gateway versus Amir Soleimani, and also in the US court systems as well, where the consumer protection laws are very quite robust. And when an arbitrator does not apply that law, or at least does not apply or deal with the domestic law, it may be subject to set aside.
And Marielle, could you give us an institutional point of view on this consumer issue?
Yeah. Well, I think there's two sides of, is it two sides of the coin? I'm not sure. There's two aspects that I'd like to just raise in this. First of all, the whole arbitrability point as an institution, and this is not unique to HKIC as I understand it, the threshold test for getting jurisdiction is very, very low. It's a prima facie threshold. I should mention Chian has written a book on this, and we quote her prima facie threshold. We quoted her prima facie threshold in several cases where we had to examine this issue, but it's very, very low. So I don't think, and even disregarding what it says in our rules, I don't think it's the role of any institution to go that far into the weeds of arbitrability when all you're trying to do is get a tribunal constituted, because inevitably determining whether or not something is arbitral is going to have some sort of factual analysis, and at the very least a legal analysis, and that's certainly not something that an institution should be doing. Just to go to the consumer point, because Chian raised it, when I was looking into this morning, I actually found a case of the Ontario Superior Court called Lochen against Binance, which talked specifically about HKIAC and has been decided since October last year, but it was not brought to my attention, so I was very interested. But one of the things that came up there was essentially that the Ontario Superior Court declared the term or the dispute resolution clause in this T&C agreement put out by Binance as invalid and unenforceable, because it essentially was against the standard form T&C's prohibition that applies to consumers. And one of the factors that they added on in declaring this unenforceable, and again I read this morning, so if there's people in the audience who know more about this, please tell me, was that it was also a cost point, because the court said that by forcing its consumers to agree to arbitration in a place that had no logical connection to the dispute at hand, Binance was essentially immunising itself against suit, because no one would be able to navigate and access the Hong Kong system that was put forward, and I understand that to be HKIAC. And in that analysis, they said that the average claims that they were seeing were $5,000 US per claim, and that if you went to Hong Kong arbitration, they had this figure of 36,000 US, and I didn't have time this morning to check this, but it also became a cost point. So I do think there's a risk out there, and Chian alluded to other jurisdictions where this is happening, where this kind of thing I think might spiral out of control if enough courts say this is actually an invalid agreement to arbitrate because of various reasons. And then from the institutional perspective, you do have, well, not even from the institutional perspective, you have an arbitrability problem, because the way in which the agreement's being concluded is not in line with a lot of the consumer protection laws.
As you know, you're here in a country where consumer contracts are arbitrable. That is very specific to French law.
I want to bring up one further topic that I find very interesting, because I've seen this in cases where I sat as arbitrator in these crypto disputes, and that's actually the valuation of damages. And Chian, I know you know a lot about this. So if there is a question of valuation of crypto assets, how do you go about distinguishing whether that should actually be done in cryptocurrency or in, you know, our normal fiat currency?
Yes, no, I thank you very much. I think this valuation of damages within this crypto space is, in fact, if you take it to what was more relatable to the general public, it is fundamentally a commodity, right? And so what we're thinking about it, we can analogize it like a commodity. So it is high value and it's low value. In particular, in this last 3 years that we've experienced the crypto winter. And so in 2021, Bitcoin was valued at 70,000. And then last year, I think in 2022, it was down to 15,000. And now we're back up to 70,000, 60,000, 70,000, something in that range. And so you can see big question marks as to how do you even start to value this type of asset. And there have been, as a result of this pendulum swing, we've had many different types of disputes arise out of that, including, as Nino had alluded to earlier, or not alluded to, expressly stated, fraud and mis-selling and other types of disputes arising out of that pendulum swing and valuation. In terms of the valuation challenges, the value of crypto asset or business will inform the party's decision as to the strategy in the first instance as to how to describe and how to strategize its own claim. Will it be a property, or will they go for the shareholding, or will they go for damages? And so that kind of strategy is part of the analysis in terms of how you want to decide or where you stand when the dispute arises. So in terms of the valuation challenges that one might face, the first question is, what is the applicable law? This might determine how the crypto asset is categorized legally. So for example, in a Delaware Supreme Court judgment, a party failed to transfer 12,500,000 coins of new cryptocurrency to a counterparty in breach of contract. This court, having observed the lack of regulatory policing of cryptocurrency, is not without the first to face this type of issue. So this type of case, in reality, was the actual cryptocurrency was valued at 25 million. but it was actually 12,500,000 coins. Now, another issue that might arise in terms of the applicable law is that it might be heavily regulated or prohibit crypto assets. So one of the issues that might arise in this particular instance is that you might have a region where the regulation changes overnight. And so that might impact, of course, how you value the crypto asset. Now, in terms of finally, the valuation of exactly how to value, of course, you have certain traditional practices like the market or the income approach. However, one traditional, one way in which valuation has taken place in the US courts is by reference to a website called CoinMarketCap. And it actually provides current as well as historical pricing information in US dollars for several thousands of cryptocurrencies. But there are still issues associated with that because it's not obviously multi-jurisdictional, and there are other issues as to that particular index. However, it is a marker for evaluation of a certain type.
I really like the reference to CoinMarketCap, because I once asked the client, I mean, how do we value those assets? And he said, you just go to CoinMarketCap. And they're like, but why? And he said, everybody does it. So it really seems to be the industry standard. But I mean, what I find interesting with the evaluation of damages, very often it really comes down to the timing. What is the relevant time to determine the damages? And here I've seen vast differences depending on the governing law. So this is really a tricky legal issue that I would recommend if you have a case that is governed not by your home jurisdiction law, really get a co-counsel, because you can get this one very, very wrong, and you do not want to have to call your professional negligence insurance because of that. So free advice.
It should be said that there are now sufficient number of cases out there where experts are becoming true experts in this particular area, and so it is worth kind of.
Yeah. And maybe a follow-up question would be, what about an award that will be, well, the valuation will not be a fiat currency, but will be a cryptocurrency? And what about this award being enforced in a country where a cryptocurrency is not seen as a regular currency, you know?
There's still some jurisdictions that are very suspicious of cryptocurrencies. So they go this far to say they're flat out illegal. And this usually raises two questions in an arbitration. First, you will see that the defense of illegality will be raised. They say the entire contract is void because this concerns Chinese citizen, and therefore all the transactions involving crypto are illegal. So those arguments are usually fun, but they rarely succeed in my experience. Then second is the enforcement. And there have been courts, at least I know of one in Greece, and I think there's also been one in China. Probably you're going to talk about this later, where they refused the enforcement. I mean, this is really important to know, because I mean, at the beginning of a case, you decide, do I want to sue for transfer of the token, or do I want to sue for damages in a fiat currency? And if you know that at the potential place of enforcement, it's very difficult to enforce a claim for tokens, you're probably not going to file a claim for tokens. So you really need to think about this from the outset of your case.
I assume that if you have an award that is labeled in Bitcoin, for example, it would not be enforceable even in France.
It would be enforceable in Switzerland.
It would be enforceable in Switzerland, yeah. Okay. Oh, okay.
So the two cases, just to follow up on that, and well, Nino has referenced that there have been two cases expressly dealt with on this, where in Shenzhen Intermediate People's Court, and then also in the Greek court, there are two cases where the cases that had Bitcoin as an award were not enforced based on public policy.
Okay, thank you very much. And if we move now to, let's say, apart from legal issues that we just mentioned, what makes crypto arbitration special I mean, from a practical point of view, maybe Nino, you have something to say about that.
I mentioned before poorly drafted contracts. But imagine you have poorly drafted contracts and very high stakes in dispute. It's a litigator's dream, I'm telling you, because you have the funds to really pursue those cases and you can get very creative. Second thing that I would highlight are the clients. They are special, and I think you have 3 types of clients. You have your fraudster, stay away from them. Then you have your investment banker, they're just in it to make money, but you can work with them, they're reasonable. Before they were selling, I don't know, other commodities, now they're selling crypto, that's fine. And then you have your visionaries. They really believe in it. For them, it's about the democratization of finance. And working with visionaries can be very rewarding, but also challenging, because they tend to not be very pragmatic. So if they want to, if, for example, it's about a governance token, because they want to have a vote in the DAO, they really want to have the vote in the DAO. It's not about the money for them. So it's very difficult to understand what kind of client you're dealing with. And in any case, I mean, always ask for money on accounts. So A, because you get paid, and B, it's a sign of credibility. And it's very easy to really weigh that there are not that many fraudsters, but they're still out there. And ask for it in fiat money. Do not accept any kind of coins, because you don't know where they come from.
Xian, Marielle, do you have any views on that?
A couple of points in terms of practical tips. I think what has been alluded to by the other speakers, and Marielle has indicated, but many of these cases are simply contractual disputes. There's nothing terribly interesting or unique about them. I mean, they're a crypto exchange, but it's also Bitcoin mining and other types of disputes. Whether you need a specific type of expertise, I think mostly it is procedural robustness as an arbitrator to deal with these types of counsel who may be particularly aggressive, but also may be less experienced because they have the one-time player and they've hired, you know, a counsel who doesn't engage regularly in arbitration. And so you really, I think there is a whole variety of types of disputes that happen to fall under the rubric of crypto assets, but fundamentally are, you know, contractual disputes. There are also IP disputes, like involving wallets and other types of disputes that are squarely in the IP space. So I don't think we have to be kind of particularly mindful of crypto disputes or finding that they are unique in a particular way. But I do think, I mean, to Nino's point, I think it is sometimes the one-time player and not terribly experienced, but that doesn't necessarily mean that you require something of particular expertise.
I think Qian's point transitions perfectly to what I was going to say from the institutional perspective. I don't think we've gotten quite a few of your clients didn't quite make it to HKIAC arbitration, but what we experienced at the institution was a lot of unsophisticated clients, and this is again back to why is there an arbitration clause and why has it come to the institution in the first place? We have many, because I'm no longer there, that were self-represented. We had many that were poorly represented. As I mentioned before, a lot of very low value disputes, but procedurally complex. And one thing that, you know, if we're going to give you a very practical tip, and this has been mentioned by my co-panelists, this is an area that's growing. So if you're out there looking for your first appointments and you have knowledge in this area, make sure you get in front of the institutions, because believe me when I say they are looking for people to do these kind of disputes who have credible background, who can be procedurally nimble, who have a bit more street cred, to use that term, than perhaps someone who's several decades older than I am, who may be doing other kinds of arbitrations at the centre. So I think that would be my most practical tip for all of you. Get your names in front of the institutions and you'll probably get some appointments following on from that.
That's a great tip for the students and younger people in the audience. So we've talked quite a bit about from a commercial perspective. I mean, all of these disputes would fall under the heading of commercial arbitration. But of course, we all know that in the investment arbitration arena, there are also quite some tricky questions with crypto disputes. And you've probably all seen the latest development in the Nexo versus Bulgaria case. So Qian, Can you help us a little bit more in understanding what the issues are when we talk about investment in crypto?
Yes, exactly. Thank you. I think I'd like to touch on two particular areas. One is whether they are protected investment, and the second area is as to the legislation that may change dramatically in dealing with crypto assets in any national jurisdiction. And the first question relates to protected assets. What is a protected investment? There are issues as to whether crypto ventures and assets are protected investments under international investment arbitration. One, mining farms. Mining farms are a huge potential area for where the question is whether they are protected investment, and mining farms are alike to any other infrastructure project, so in many ways it could be seen easily analogized in that space. The harder question, I think, is whether the crypto asset itself is covered as a protected investment. And such cryptocurrencies are held in wallets and held by third parties that function like traditional banks. And if such wallets become unavailable as a result of state intervention, then there is maybe a question as to whether they are covered under protected investment because of the nature of the beast, so to speak. But then you look, there have been analysis out there, it hasn't been tested yet, as to whether it does squarely is covered under, for example, Article 25 of the ICSID Convention, or the other tests associated under that define protected investment. But generally speaking, there has been enough scholarship to indicate that there is the possibility that they are covered in this space. The other area, as I mentioned, is in relation to legislation. Now, this is the more interesting area, I think, in terms of the potential, the likelihood where an investment arbitration might arise that involves cryptocurrency or crypto assets. There has been much regulation in all jurisdictions involving crypto, and they have not necessarily been informed. Part of it is reactionary, part of it is defensive, part of it is protectionist, and so the type of legislation that is drafted is challenged domestically, as has been seen in the U.S. courts. And part of it is that the national legislation, it may sometimes be too robust and then may swing back in the other direction. And I'll speak about this in a separate section, but the impact on the environment of these mining farms are truly squarely in the zone of a potential investor-state arbitration. And so this area is particularly, I think, ripe for the picking, so to speak.
Yes, now maybe we will move to the elephant that is in the room, which is we spoke until now of arbitration. I mean, regular arbitration confronted with the blockchain and with the crypto assets, and now we will address another issue, which is blockchain-based dispute settlement mechanism. Because, as you know, there are several proposals coming from several startups like Liros, like Aragon, and they propose some specific blockchain-based dispute resolution mechanism. Marielle, do you have any views on that?
Thanks, Matthias. So as Matthias introduced, this is a slightly separate topic, but we agreed between us on the panel that this panel should also cover this. In terms of, I'll focus on Kleros, and I'm not picking on them in any way, but it's just the one that has the most information available, and I'm fully aware that there are many coming up and many quite recently. My view on this is that it's an entirely separate system. They call it arbitration, but if you look online about what it is, and you look at what also other people who are much more into this space than perhaps I am, they're calling it arbitrations, but it's actually something else. I had a discussion with a couple of people in Hong Kong who are also quite active about this, and the general view seems to be that Kleros is suited, and it appeals to people who are working in a metaverse because it's part of the same self-contained system that you have there. And just to sort of take a step back, for those of you who don't really know what this does, essentially you can submit, if you're in certain blockchain universes, you can submit disputes to Kleros. And there was an example that I read when I was preparing for this that really stuck with me. It was essentially Alice and Bob. And Alice has a dispute about whether Bob has performed her smart contract correctly, and this is all in the scope of smart contracts, which is a very important point to note because these are essentially binary contracts. There's a set of instructions that need to be executed, and when it comes to a dispute, what happens when it goes to Kleros is that the jurors, as they're called, and there's 3 of them usually, are presented with a series of options that they can decide. So in the Alice and Bob option, essentially, did Bob perform as contractually agreed or did he not? And one of the things that kind of stuck with me when I was reading this example was they had the example of a juror accepting the mandate as juror because he had a certain he'd put a certain number of tokens into this, and I'll get to that in a moment, in which case he was given the case file, and in the example put out by Kleros, it said he read it on the bus on the way home. And for most of us arbitration practitioners, you know, it'd be nice to get those cases where you can read the evidence in the bus on the way home. But firstly, there's a whole confidentiality element there that I haven't really thought through. But also it kind of shows the simplicity and, again, the binary nature of what you're being asked to do. The other thing that really I think makes Kleros an entirely different form of dispute resolution is the way a decision is made. You don't know what the other jurors on your case are going to find, but if it turns out at the end of the day that you were in the minority, you're essentially penalised for coming to a different decision, and your tokens that you put in to act as a juror in the first place get reallocated to the people who got it right. And it's a very interesting system, and it shows the reliance and the trust that people on the metaverse have in their peers. And yes, it does probably ensure that the most popular view comes out, but I personally find any form of incentivized dispute resolution slightly problematic for a variety of reasons. Kleros advertises on its website that they think their approach to dispute resolution is transparent and secure. I don't disagree with them, but I don't think it has much in common with traditional arbitration. But again, I think this is, and we'll get to this in a moment, this is where the interface becomes quite problematic. If everything's on-chain and you're in your self-contained system, this is going to be fine. But the minute you're getting to the point where a clause is put into a contract that provides for an traditional institution, you're not going to have the on-chain system, you're essentially going outside. And even Kleros itself says that the system doesn't work particularly well, and I'm paraphrasing, if you get to the point where you have to go outside the metaverse for an element of the dispute that isn't solely contained on-chain. So I do think there's a role for that, and we'll get to this a little bit later. I do think the convergence between traditional and on-chain arbitration will probably be driven by the metaverse itself and not by the traditional arbitration users. But from where I sit, I think there's a huge mismatch right now, and arbitration is regulated. You need a seat. You need a hook and an anchor in national law most of the time, leaving investment arbitration to one side. That's precisely what users of the metaverse don't need, and I don't think they actually want it either. So the expectations from the beginning are not really lined up. So it'll be interesting to see whether they will line up, but I don't think it's going to be the traditional arbitration users who'll be driving that push to get closer together.
Any views on this by the other panelists?
I mean, coming back to the 3 types of client that I described before, the fraudster is not going to go for it because he's not going to go for anything. The investment banker is not going to go for it because with the arguments that have just been made, we probably have the visionaries that will think about it. And I mean, if this would be a reasonable chunk of business that would go that way, but I'm also skeptical of the mechanics at play within those systems. but it's very interesting to look at it. Read the white paper.
So, mindful of time, maybe one final question, one for each of you, and this is sort of looking a bit into the future. I'm going to start with you, Marielle. Do you think our existing, you've just talked about institution rules, but do you think our current and existing institutional framework is fit for purpose for these crypto disputes? And I'm sure there will be more in the years to come. What do you think?
Short answer is yes, I do think it's fit for purpose. And leaving aside the whole metaverse that I just spoke about, I think all institutions have a lot of flexibility in their rules. You can go to, so one of the things I did in looking at this is I looked at some of the institutions who've put out draft online dispute resolution rules, including JAMS, and again, not singling JAMS out, but they gave me a lot of food for thought. They talk about having EA proceedings, emergency arbitrator proceedings. Most rules have that these days anyway. They talk about the role of party autonomy. Most rules have that as well. They talk about expedited procedures and certain things having a turnaround of 72 hours. Again, you can go to the emergency arbitrator procedure, or you can go to an expedited procedure and essentially agree on that with your arbitrator within the expedited timetable. They talk about e-filings. Most institutions are going to that now. I'll put a big caveat out there, except if you're doing enforcement in or if there's enforcement likely in certain jurisdictions where you're worried about e-filing. And the reason I say that is because we had an ongoing issue with that about our services at HKIC with respect to enforcement in China. But I'll leave that to one side. So I think the existing rules that I'm aware of all facilitate what these specific rules are trying to achieve. I think the clarity is helpful and welcome, but I personally don't think there's a reason to overhaul the current system, because even with that additional clarity, and this goes back to my point initially, if you've got sophisticated counsel who don't want to play ball, they're going to find a way to delay the system anyway, or to put a spanner in the works that, you know, would have been there whether or not you had tailor-made systems. So I think the system will work. You've just got to pick the right arbitrators so that you get the expedited procedure that you're looking for, you get the flexibility that you're looking for, but it's not a problem of the rules itself.
I'm going to look forward to maybe some comments from the audience on this as well. We have the Q&A coming up soon. But before that, Chan, you mentioned earlier the intersection with environmental questions and, you know, the mining farms. Could you develop a little bit what you have in mind?
Yes, I have observed the impact on these mining farms for some time. And let me just give you some statistics associated with this. A single Bitcoin transaction uses up the same amount of power as a single US household for over 3 weeks. Cambridge Bitcoin Electricity Consumption Index estimates that Bitcoin's annual energy to be about 150 squared terawatt hours. In some instances, the consumption of energy exceeds the energy usage of countries such as Chile, Colombia, Austria. This is the volume that we are talking about with mining Bitcoin. And I mentioned just now that we're now back to the good old days of $60,000, $70,000 per Bitcoin. Mining farms are not going away anytime soon, and they are clearly having an impact on the environment. Climate change litigation is a normal thing now. And so no longer are companies or individuals shy of commencing litigation, arbitration, or any type of suit against companies that are creating environmental harm. So this ties in very nicely to what we're talking about in terms of the crypto world and its impact on the environment. Of course, this is not just the environment that is impacted. There will necessarily be economic impact as well. And so we're not just talking about investor state arbitration, but the number of litigation, arbitration that will happen in relation to the creation of mining farms around the world will certainly rise, I think, in real numbers. Now, where they will happen will depend on what countries remain friendly to mining farms and what regulations are happening within these countries in terms of reducing the harmful environmental impact. Some countries are engaged with now reducing, the fossil fuel and looking at renewable energy to engage with these mining farms, but they won't be happening quickly enough. And other countries are outsourcing. So, for example, like in China, they are reducing the environmental impact themselves, so less carbon emissions in China, but they're moving it to Kazakhstan. And so this is where I think we'll see a lot of impact and engagement in the dispute area for some time.
Nino, final word, and look into the future from you?
Magic crystal ball, I like that. I think we will see a general rise in crypto disputes again in, say, probably not this year, but next year. Because, I mean, the price of Bitcoin, it's a good indicator of how much activity and investment there is in the crypto sector. So, like 2021, 2022, disputes-wise, great years. 2023, not so great. Because you can see disputes slowed down because it was the aftermath of the crypto winter. So this sounds terrible, I'm going to say. I hope for more crypto disputes. I hope no clients are listening.
Well, we are now going to turn the floor to the audience, but I think before we do so, we should give Marielle, Chan, and Nino a round of applause.
What is specific about crypto arbitration? You didn't say it, but it's fun. It's really fun. You start with a case where, parties argue that there's been a hack and a glitch in the system, plus possibly a fraud, and in any event, the contract was not correctly performed. And that's where the fun comes, because usually the merits are the sort of the case, and procedural issues are 5 to 10. And here, it might take most of your time on procedural issues. The contract, what is the contract? Which version? If you take Binance, then which institution? You started with Singapore, then turned ICC in Paris, and end up with Hong Kong. And then also, you discover that, this is an area where the contract has no law, the arbitration has no seat, and in fact, you have no parties, because it's for the claimant to determine which is the counterparty, because he's dealing with the platform, which entities are the platform. You do not know that. So it's mainly, the difficulty is procedural issues, not the technicalities. And just one quick word on Kleros. I think it's very interesting that you touched upon that, because I know Kleros quite well, and I've appeared on several panels with one of the founders, Federico Ast, and he knows that we do not agree, but they market aggressively their product as arbitration. It is not arbitration. As you said, it's designed to provide a yes or no answer to a question, so it doesn't address disputes. It addresses disagreements. So that's what I just wanted to add to your presentation. And sorry, this is not a question, but thank you again very much.
Thank you, Christophe.
Any other comments or questions from the audience? Yes.
I appreciate your presence here. My name is Noor Amajaj, and I have a new idea. We can make a new convention, international convention, to have a solution for many problems. Because with the new convention, we can have a new strategy for making new facilities for the investments and also for the projects, new projects. For this, we need a new convention, international convention, to solve these problems.
I think a any area would be suitable for an international convention, this would be it. But I have absolutely no idea how we go about achieving that. So I think your idea is a great one.
It might be an issue for UN CITRAL in order to draft a new convention.
I think the problem is that the nations themselves are still trying to figure out how they're supposed to deal with this. So before we can find a consensus on an international level, I think we need to give the nations some more thinking time, because I don't think they're ready yet to discuss a convention, although it would certainly be beneficial.
The other aspect, of course, is that to your point about national interests, I think every country has its own interests. So for example, a country like Iran is very much welcoming of this system because it allows a roundabout way to deal with sanctions, for example. So there are challenges.
Yes, please, Amy.
Just a quick question. You touched on, this is Amy Kleisner, Jones-Day. You touched on issues of valuation, and that was a big issue in a case that I saw. Because we need an amount in dispute from an institutional perspective as well. Is that amount in dispute in dollar or whatever the institution's currency is? Is it in Bitcoin? Does it, is it one value on day 1 and another value on day 2, another value on day 30? In fact, the claim that I saw was filed strategically as Bitcoin was sort of at its zenith, but the claimant was unwilling to specify whether they actually wanted payment in Bitcoin or in dollar, obviously speculating on the back end that it could go the other direction. So we have this sort of uncertainty. You also then don't know, is it a big case, is it a small case, what level of effort do you throw at it, procedurally speaking, what's appropriate. And then contractually, I'd be curious to see sort of what mechanisms you've seen for dealing with that risk. I've come across extreme interest provisions for late payment, like 20% per month on the principal, trying to sort of deal with this issue. And it struck me, going back to the first panel, that it's actually going really maybe to a question of, am I owed, an equivalent value in something, or am I owed the Bitcoins themselves? And I never really thought of it in terms of that academic sense, but I think that's maybe what it's going at. Anyway, a lot of disparate comments, but perhaps just inviting your thoughts on how we get a handle on this radical, currency fluctuation.
I'll just refrain from speaking too much on this, given my live cases. But I do think, as to my earlier point, I do think that experts do have some experience in this area now, and so it may be worth engaging with an expert at the outset of your arbitration to understand how your strategy might play out.
As regards the amount in dispute, what I usually did, I just took the value at the date of filing. So far, no complaints. Regarding the issue of risk and how you can mitigate the risk of currency fluctuations, I mean, if it's a debtor's default case, I mean, there are the laws attributing that risk. If the token in question or the currency in question is traded with a high volume on exchanges, you might be able to hedge this. But it's not as easy to hedge risks in crypto than it is, for example, in other fiat currencies. And the problem is sometimes you're able to hedge certain currency for a duration of 12 months, and then there's no hedging available anymore. So it is really a nightmare, the volatility.
On the same topic, I would think that it's first of all a question of timing. So as you said, you need to determine a date, and it's a filing date for the value at stake. It will fluctuate. Then what you claim might vary, and at some point, if it's really it has increased, the parties or the arbitrators might want to ask the institution to revisit the fees. And then I think the last issue is really a question of enforcement. So at this stage, what do you ask the tribunal to do? Do you ask the tribunal to condemn the party to pay in US dollars or euros or in fiat currency or in a crypto? In that case, you must be certain that the place where you will enforce your award is a place that is crypto, favorable to cryptos, because in some instances, cryptos are banned. So you will have a nice award in cryptos that would be worth nothing. So I think currently most of the case, I think, would be denominated in dollars or another fiat currency, not cryptos, unless we have enough countries that would recognize cryptos as a means of payment, which is not far from being the case.
Thank you, first of all, to the Sorbonne Law School for hosting this event, and to, of course, all our speakers, including the first panel, and the excellent questions and comments from the audience. But I think, Matthias, now we are heading for drinks, right? Yeah,
it's going to be light drinks. So there are some light drinks outside down there, because we assume that everybody is heading to the opening ceremony of the PAW. So we thought it would be better not to have something with too much alcohol in it. So and we're a French university as well, so we are very poor. So that's why it's going to be a light drink. And thank you very much for the panelists. Thank you, Maxi. Thank you, Maria, for co-organizing this with us. And we've been very happy to have you all as panelists in the Sorbonne. Thank you very much.